Panel to talk about this case. Joining me now is criminal defense attorney Trinity Hundredmark and Quentin Washington, magistrate court judge. Quentin, Trinity, thank you so much for being with me. You guys have been staying on standby this whole entire morning. There's so much to talk about with just this expert alone. Right. Okay, let me start first with this witness. What do you think about the strength of his performance on the stand? Is he a good expert for the defense? Quentin?
Oh, he's incredibly strong. And that's why I think that, and I know Prosecutor Murder because we went to law school together, but I would have gotten him off the stand as soon as possible.
Okay, so we're gonna get back to that topic. Trinity, tell me why you think this is a expert who is a good witness or maybe a bad witness for the defense.
Oh, I think he's doing phenomenal. I mean, what he has done is he's established another theory, right? He's established another way that this has happened. And he said it with such definitive confidence that, I mean, it's absolutely planted reasonable doubt. It's absolutely. I mean, he has said this happened from a fall. This did not happen from abuse. This did not happen from punches. This did not happen. And then he's taken the statements that the defendant said and corroborated what he's found by reading the other, the other pathology report. So he has just done a tremendous job for the defense in this case.
Okay, so this is going to be the only witness that the defense puts up today. Should there be more called to the stand? And if you think so, who? Quentin?
I think they should call other people that work at the facility to discuss the fact that there were too many people at the facility for the care ratios that they had.
Got it.
Right? And that's important. But also, you got to put in more of the history of what was happening with Bennett at the home.
Exactly.
And then at that point, you have, I mean, you got your acquittal witness, first of all, on the stand. Like, he's the acquittal witness. Like, that's the person you want. But then you can buttress that by having additional people come up as well to testify about how the home wasn't running the way it should have been. Because,
the defendant here had to care for 20 people at the time that this incident occurred. And so they were understaffed. And of course, they have some responsibility for what happened to Adam Bennett. Trinity, tell me about this felony murder and how, well, first, do you think that the defendant is being overcharged?
I do. I mean, well, first of all, overcharged in the sense that the prosecution can bring these charges. They can. I mean, the law is there. They're allowed to do it.
Should they have?
Certainly. Should they have? I don't think this is a murder case. I mean, this to me does not seem like an incident where he beat this man to death out of anger, out of whatever. There is no indication of malice. And going back to the question you asked previously, would I want to see other witnesses? I would have wanted to bring other witnesses from the facility that would talk about what a good caregiver he was, how he took care of other patients, how he wasn't easy to frustrate, how he wasn't, just taking out his anger on somebody else.
There might have been a few, prior incidences where Terrell had some anger issues or even threatened a former employee is what we were being told. So if that were to be the case, that may actually come up. So I think that that's where the defense wants to stay away from.
Sure.
But
Go ahead.
Let me just also say this. I think that what Trinity said was incredibly true, but here's what happens in this process, right? You get an arrest warrant by showing a preponderance of the evidence, right? But then you also then go to the grand jury, and the grand jury raises their hands, and those are voters in that district that says, we believe you have enough probable cause to go on to get these charges. So it's not as if there weren't safeguards that they try to put in place to stop them from being able to overcharge, et cetera. This went through the formal process. Now, that may say something about the formal process of how do we get warrants and how do we get past the grand jury if there's nothing really there. But it got past the formal process, so they're just bringing the charges that the voters said that they could go forward with.
Right. Well, Trinity, I got to get a quick commercial in. My panel, y'all are going to be standing by. I promise I'm going to get your thoughts on the other side. Court is in a short recess. We'll get you back into the courtroom for cross-examination of this expert witness. This is Court TV, your front row seat to justice.
Do you understand if you choose to testify, you will be both examined by your lawyer and cross-examined by the assistant district attorney? Do you understand that, sir?
Yes, ma'am.
Do you personally want to testify or not?
No, Your Honor.
All right.
Welcome back to Court TV. That was the defendant, Landon Terrell, telling the judge he won't be testifying at his trial. My legal panel is still with me, criminal defense attorney Trinity Hundredmark and former magistrate court judge Quentin Washington. Okay, one thing I really, really want to talk about with you, Quentin, in particular, because of course you're a magistrate judge. The arrest warrant that is the basis for the probable cause that was established to make the arrest of Terrell. So it says here, and you have a copy, and so do you, Trinity. Accused did admit to striking the 91-year-old victim in the torso during the overnight hours of 8/14/17 through 8/15/17, causing the victim to suffer pain, visible injuries, and severe internal injuries to include, and it continues on and on. But the part I'm focused on is the accused admitted to striking the victim. And we heard nothing from the state's case in chief of an admission by Terrell. And he was saying, the only thing he said, and he was consistent on 3 or 4 different occasions when he was interviewed by law enforcement, that he did not strike Bennett and that the only thing he was guilty of was not reporting his complaints of pain. Now, tell me, you sign warrants all the time as a judge. This is incorrect information. Tell me how easy it is for a warrant to be signed by a judge. And in fact, the defense attorney in his opening statement said it's easy for your name to appear on one of these documents, but it's not easy to prove the crime, that the crime that was done beyond a reasonable doubt. So as easy as it is to get charged with a crime, tell me how easy it is to get an arrest warrant signed.
See, this is where the difficulty in the system comes in, because you have, many times in counties, you'll have one judge sitting, and it's called electronic warrants, and they'll be 6 to 12-hour shifts. And so what happens is the officer calls in, and the officer calls into your terminal, wherever you are, and you log on to the terminal. You swear the officer in. The officer many times will be at the station or they'll be at the jail, and you'll ask them questions about what's contained in the body of the warrant, right? So I'll ask, did you get this confession? What happened? What are you seeking, et cetera? And we'll go back and forth about that. But remember, I'm not getting anything from the other side. So when the officer under oath tells me that this happened, there's no way for me to know it didn't happen because there's nobody from the defense there. There's only the officer. At that point, you don't even have attorneys involved. You only have the officer telling the testimony about what happened. And so I have to, when they're under oath, I have to believe what the officer says, and I ask questions about anything that I think doesn't sound correct or that I want further background on. But then when they swear on the oath that this is what happens, many times I will sign the warrant, and it's off to the races at that point.
Well, you know what, this issue of the affidavit having incorrect information by the actual detective who made the arrest, Chad Britton, our legal correspondent, Chanley Painter, actually spoke to him after he got off of the stand yesterday to ask him specifically about this arrest warrant. And she is standing outside of the courtroom in Cobb County. Chanley, we're talking about this affidavit for an arrest warrant here with my panel. And as easy as it is for a judge to sign off on this, they were basically signing this warrant with information that wasn't accurate, whether it was intentionally done or not. The fact of the matter is we didn't hear an admission at all one time from any of the witnesses presented by the state in their case in chief. And you spoke directly to Detective Chad Britton, who went and got this arrest warrant signed. So tell us about that.
He said it was his interpretation of what Landon Terrell told him during the audio interview. He said the part where Terrell says, "I hit him in the chest," is what the detective said he used to make that statement that he admitted to striking the 91-year-old. When we listened to this audio and when he's talking about that he hit him in the chest, it was when he was describing, like we saw in the video reenactment of Mr. Bennett falling out of the bed, Terrell catching him and putting him back in the bed. And so that was his explanation to me yesterday, because I was hearing the same thing. I was anticipating some sort of an admission or a confession in these audios, and we did not hear that.
Wow. Okay. So you were on to that, obviously. I mean, you being a former prosecutor, you were also aware that there was no admission at all when the state's case in chief was done, correct?
That's right. In fact, I didn't even hear it in the opening statement, so I was put on alert right from the beginning, Yodi. Based on our research of this case, I was anticipating the prosecutor to say that right off the bat. That's a strong piece of evidence for them, right? If he's admitted to abusing this victim in some way. I didn't hear it then, so then I was already on alert throughout the entire case in chief, and so that's why I wanted to make sure, where did that come from if the arrest warrant claimed that he admitted to it?
Yeah. Okay. Well, Chanley, let's go ahead and switch gears to today's testimony with this expert pathologist for the defense, seems to be a very strong witness for the defense, and it got pretty hostile between him and the prosecutor on cross-examination. Tell me what the jury's reaction to this witness is. Are they receiving the testimony? Are they paying attention? Just tell me what it is that they are feeling towards this witness, if you can gauge their thoughts.
They are very attentive to this witness. They're taking notes and paying attention. I have to say, it went a little far, though, when the experts started talking about the voice of Mr. Bennett on the voicemails. You could see, because the witness was saying, oh, he didn't sound as if he was in pain or struggling. And I could see in the jurors' faces a little bit at that point that they were like, disagreeing with the expert a little bit there. But other than that, they seem to be taking in what he's saying. But I have to say, Yodit, the courtroom is jam-packed today with people in the gallery. I'm sure you can see that on our cameras, but we have a lot more family and friends of Landon Terrell out there in the gallery, including his wife. I think one of his child, one of his children, 3 children, is there as well. And then on the other side, we have even other deputy prosecutors here to support Mr. Marbut, as well as the family of the victim on this side with the grandchild. So there's a lot going on in that courtroom.
Chanley, so this is going to be the only witness for the defense. When can we expect closing arguments to happen?
We can expect them to happen pretty soon after we wrap up with this witness. Not sure how much longer he will be on the stand, but we can anticipate closings today, even the jury getting the case if the prosecution decides not to call any rebuttal witnesses, which is probably unlikely.
All right, Chanley, I'm hearing that the judge is on the bench and the jury is also in court. So I'm going to go ahead and let you get inside and also take our viewers back into court.
And you're testifying then that when he gave a different description of what happened to him, Mr. Bennett, that he imagined it.
What description are you referring to, sir?
Well, Mr. Bennett says he was hit. He says he was punched. You're saying Mr. Bennett imagined that.
I'm saying that I discount that history based on what I see from the examination of his body.
You discount that history. You gave the example on direct of a patient back when you were a med student of lying. Is that what you mean by discount the history?
I don't believe the history to be valid, sir. I don't know that I would call it lying from someone who has dementia. In the case that I was referring to, the patient was lying. It's a little different. It's maybe subtle, but there's a difference there.
So it's your belief that Mr. Bennett, I guess I used the word imagined, what word would you use? But
Confabulate.
Confabulated that he was punched.
I don't have any doubt that that's what he said. I'm just saying the evidence doesn't support that.
And part of the reason that you, I guess, made that, or formed that opinion is because you believed that he had Alzheimer's.
No, sir. As we discussed at length, I thought he had changes that are characteristic of Alzheimer's.
You wrote a report. You said that, right?
I believe what I wrote specifically...
Sir, my question was, did you write a report?
Yes, sir.
My next one is going to be, do you have it with you?
Yes, sir, I do.
It's in front of you.
Yes, sir.
So I want to direct your attention to page 2, subsection, I guess, I. Does your report read, changes of Alzheimer's dementia?
That's the first part of that citation, yes, sir.
Okay, and that's under the section where you talk about significant autopsy findings included, and then you give a big list of the findings from Dr. Gulledge's autopsy, correct?
That's correct.
And then, but in I, you wrote, changes of Alzheimer's dementia, cerebral neurofibrillary tangles, and amyloid plaques.
Yes, sir, with a footnote that references exactly what I'm talking about.
Okay. Your footnote references a citation to some research articles or something of that sort of, correct?
It's a medical publication, and give me a second, I'll pull up exactly what that citation is.
I don't need you to.
I'll object, and I would ask that the witness be allowed to finish his answer.
He can finish his answer.
This is the journal article that I referenced, Neuropathological Alterations in Alzheimer's Disease.
But the beginning of, so that's the citation for that, but the beginning of your report says these are significant autopsy findings. So you're citing to Dr. Gullich's report, correct?
I'm taking the information that he documented such that it is, and then applying medicine, my knowledge of medicine to that.
Okay, but that's not what it says. It says significant autopsy findings included. And then A, you talk about the coronary artery disease. B, you talk about the how do you say that word?
Cardiomegaly?
Yes, sir. Cardiomegaly. Then you talk about the aortic stenosis, the atherosclerosis, the left renal, say that word.
The pyelonephritis?
Thank you, sir. There's a reason that you and Dr. Gullich are trained in that, right? So you look for those things, and when he does the autopsy, he's making notations of the things he's finding in the body, correct?
Correct, but I do take my medical knowledge, for instance, I don't believe his phraseology in A under that borderline functionally severe coronary artery disease. He didn't say that. I took his findings and rendered my opinion of what was there based on what he said. He said there was 50% narrowing of the proximal anterior descending. Clinically significant is 60%.
He also didn't say Alzheimer's, did he?
And I didn't say either, sir. I said it was changes of Alzheimer's disease. I did not say he had Alzheimer's disease. Unfortunately, Dr. Gullich did not do a neuropathological examination for Alzheimer's disease. I don't believe he's a neuropathologist. And if I were to want...
Judge, again, I would ask that the witness be allowed to finish an answer.
Yeah, he can finish his answer.
And Judge, I would ask that the witness not go into narratives when I haven't asked for a narrative.
All right, well, I'll let him finish this answer.
Sir, I'm just trying to answer your question. If I had done an examination for Alzheimer's disease, I would have sent the brain to a neuropathologist for that very specific reason, which I've done as recently as this year.
You're not a neuropathologist yourself.
No, sir. Like I said, I would send the sample to someone who was.
So this is an error in your report where you are saying that Mr. Bennett had Alzheimer's.
I didn't say that, sir.
Okay, because you agree with me he doesn't have Alzheimer's.
No, sir, I'm not. I'm saying he has changes that are characteristic of Alzheimer's, and that's all I'm saying. I'm not diagnosing him with it. I'm not saying he has it. I'm not saying he doesn't have it. I'm saying that these findings are common findings that are characteristic of Alzheimer's, and that's all I'm saying.
Cerebro-neurofibrillary tangles and amyloid plaques can come from things other than Alzheimer's, correct?
Yes, sir, but they're not characteristic in those other things.
But they can come from things other than Alzheimer's.
Actually, when you look it up, I did not find really anything else that saw those two in association, but inflammation non-specifically can cause plaques, and neurofibrillary tangles can happen from something else. So it is possible to have each
This
of
is
those.
Dr. James Downs, the only witness the defense is expected to call today. His cross-examination continues after the break. This is Court TV Live, your front row seat to justice. Welcome back to Court TV. We're bringing you live coverage this morning of Georgia versus Landon Terrell. The caregiver is accused of beating an elderly patient to death at an assisted living facility. On the stand right now still is Dr. James Downs, a defense expert pathologist, being cross-examined by the prosecutor. Let's get you inside.
So, while I would look at them, and I do have multiple entries in my report that I can go back and look at about what was said at the time, I believe most of them he mentioned or he said in some way, shape, or form that he felt.
Do you have defenses 10? Thank you. I'm going to show you defense exhibit 10. Have you seen those medical records before?
I believe so, yes, sir.
I'm going to ask you to turn to page 41.
Yes, sir.
What are the medical conditions listed under current diagnoses for Mr. Bennett?
I do not, oh, I'm sorry. Aortic stenosis, hyperlipidemia, depression, GERD, which is reflux, BPH, which is prostatic hypertrophy, and dilated aorta, mild memory loss.
I'm sorry, you paused and then stuck that last one in there. Can you say
That's
it again?
because it was on a different line, sir, and it's actually under the caption on that line, so I wanted to make sure it actually went with the other list.
And I want to make sure the jury heard it, so can you say it again, please?
Sure, I'll do them backwards this time. Mild memory loss, dilated aorta, BPH, GERD, depression, hyperlipidemia, aortic stenosis.
Is there a section there that says mental health limitations?
If you could direct me to it, it would be a lot easier. This is not a really good copy.
Is it 2 lines down from the mild memory loss?
2 lines down says primary physician.
And look, make sure we're looking at the same document. I stand corrected. I am looking at a different document which I reviewed because there are multiple documents which document mild memory loss, correct?
Yes, sir.
Did you look through the Sunrise Assisted Living Facility records?
Yes, sir.
I'm going to show you what I'm going to mark as State's Exhibit. I think I'm up to 60, but I've got one, so I'm going to mark this as 61. I have a 60. It's my pre-marking. I'm going to move on. Did you find in any of the medical records that you reviewed a diagnosis of Alzheimer's?
I believe there was mention of it in one place. I believe that may have been from an EMT record, but I don't believe I saw an official diagnosis anywhere.
Did you do any investigation yourself to figure out what the mental health diagnosis was of Mr. Bennett?
No, sir. Other than looking at the records.
You would agree with me that these diseases that you are describing, Alzheimer's, dementia, I guess to some extent you're saying the normal aging process, that it affects everybody differently.
That's true.
You would agree with me that even if he has dementia, that in and of itself doesn't mean that everything he says has to be discounted.
No, sir, it doesn't. You have to evaluate whatever, any patient for that matter, whether they're demented or not. You have to evaluate every statement that they say.
And just like you made an evaluation as to his ability to go back and look for falls, if you want to make an evaluation of his mental health and his ability to know what's happening to him, you should go back and look at that.
To the extent that I'm able to, I would agree. That's why there are records to document findings. To the extent that that information is available, I have it.
And the best people, or the best way to make that determination would be to talk to the people who interact with them on a daily basis.
I would say probably the best way to determine whether or not he's got a diagnosable form of dementia such as Alzheimer's would be to actually do the neuropathological examination. That would be the best way to get that specific diagnosis. You could also talk to people around him to get a clinical diagnosis.
Well, and the first part of it, you're talking about if he's alive, that's the way you would do it. You would actually interview the patient.
No, sir, actually that was the first way was autopsy, and I would hope I wouldn't do that on a living patient.
I was next going to ask, how does that work with a deceased victim? Okay. So the next step, if you can't interview the patient themselves, would be, I think you agreed with me, to interview the folks who interacted with him on a daily basis.
Well, what I said was, I think what you asked me was, how would you diagnose it? And as a pathologist, I want to see the tissue diagnosis. The other way is to get a clinician, not necessarily people that were around him, but a physician who specializes, a neurologist, for example, in brain pathology in living people in order to assess what his state was. That would be my gold standard, if you will.
Defense expert Dr. James Downs is definitely holding his own on cross-examination. More of his testimony is still ahead. After the break, this is Court TV, your front row seat to justice.
It's time to go beyond the headlines and into the courtroom. Court TV is back.
Back with live gavel-to-gavel trial coverage.
The killing was done with premeditation.
Back with America's most compelling criminal cases. And back to bring you true crime in real time.
The all-new Court TV, your front row seat to justice.
Forensic pathologist Dr. James Downs still on the stand under cross-examination with Jason Marbut with the state. Testing exchange. Let's get you inside.
So June 25th of 2019, just a couple of weeks ago, is when you were officially retained?
If that's the date that you said, and I apologize, like I said, I was driving, I wasn't taking notes.
Well, we spoke just the very next day after you were retained, right?
As I remember, yes, sir.
And at that time when we spoke, so let's assume for the sake of the question, that would have been the 26th, you had not completed your report yet.
No, sir, I had not, I hadn't really even begun to get into the materials.
So you had just been hired on the 26th, we talked on the 25th, we talked on the 26th, and you indicated you were going to work on the report and try and get it to everybody the following, what, Tuesday?
I said I would make every effort that I could to get it to you for the following Tuesday. I know I don't know precisely what they are, but I know there are requirements to get written reports out as in a timely manner, and I did that to the extent that I was able to do it. And as I told you in our conversation yesterday, I apologize that I wasn't able to do it. There was more work and research to be done than I anticipated. So one of the benefits of working for myself is I got to work on July 4th preparing your report, which I then released on the 5th.
You've anticipated some of my questions, but I just wanted to be clear. So on direct, you said that you'll only take, or back when you worked for the state, you would only take cases for the defense if you gave the report to everybody, because you wanted to be fair.
Yes, sir, that's correct.
But you don't work for the state anymore, so are you still following those same ethical strictures, or that's just out of the goodness of your heart?
No, sir, what I said was I was prohibited from doing any work for the criminal defense. That was unethical. If I'm a neutral party, that is unethical, that I am not allowed to take a defense case because there may be validity to what the defense has to say. If a competent, experienced medical examiner cannot look at a case, then who's left to look at the case for the defense? It's a different world when I'm working for myself because I am not in that position of being an absolutely objective, neutral party employed by the state. Here, I am asked to look at a case if I'm hired by the state, which I am routinely. I will do the same thing that I did here, which is I'll issue a written report and give it to the attorneys. What you lawyers do with my report after that, that's not me.
So you finished your report on July 5th?
Yes, sir.
Last Friday?
If that was last Friday, yes, sir.
Did you remember whether you finished it in the morning or the afternoon?
We talked about that yesterday, and I said I don't recall. I didn't want to tell you one and be wrong, so I said I don't remember.
Okay, and that's still your answer in front of the jury today. You don't remember whether you finished that report, that you worked all day, 4th of July, and into the 5th on whether you finished it in the morning of the 5th or the afternoon of the 5th?
No, sir, to me, it's not really important when I finish it. What's important to me is that I did finish it.
Do you have any idea why the report would have been given to the state only on Monday?
I can give you an idea that occurred to me. I don't think it's speculation, but I've had this happen in the past.
Do you know? I'm not asking you to speculate. I'm asking, do you know?
I know what commonly happens when a report doesn't go through. I can't speak to this specific case.
If you want to speculate when it's convenient to you, then go ahead and speculate.
Sir, as I told you, I don't. Despite you saying that several times, I just don't. Which is why I didn't answer the question.
How much are you being paid in this case?
About $150 an hour, $6,000 total.
I'm going to show you what's been marked as State's Exhibit 60. What is that?
This is my fee schedule from last year, which is still current.
Judge, I'm going to tender into evidence State's Exhibit 60.
Any objection?
I know I need to look at it, but I'll glance at it. I don't think
Okay.
I'm going to have an objection, but
Okay.
not sure how it's relevant. No objection.
All right, it's a minute.
Shantae, would you mind? So it should be displayed on the board there, but you've got the document still in front of you. Is that
Yes,
correct?
sir. Yes, sir, that's correct.
So your fee schedule shows first $1,000 to just do a consultation, right?
Look at records or a limited amount of records and have a discussion with an attorney. Yes, sir. Typically, that's about 2 hours.
And I just want to be clear, because you said on direct that you do that for free on occasion. Did you do that for free in this case?
The initial consultation, probably so. I don't remember specifically, but Mr. Hendrickson probably called me and said, I have a case. I wonder if you might take a look at it for me.
When was that?
I couldn't tell you. I deal with a lot of cases, sir, and a lot of people call and tell me they're going to send me something and they don't. Something else comes up. So unless I actually get materials or have an agreement with somebody, it's not really important to me.
So you were formally retained, you said, I think we agreed it was on the 25th, thereabout.
Yes, sir.
Okay, would this have been the same day as that?
No, sir, it probably would have been before, but I couldn't tell you when.
Months?
I couldn't tell you when.
Weeks?
Couldn't tell you when.
More than a year?
Couldn't tell you when.
Now it also says in there, I guess, you said this is up to $6,000, but that's $6,000 a day. Is that how much you're being paid for today? You said today was going to be 12 hours, right?
No, I was using that to calculate the numbers. Actually, I left Savannah about 4 o'clock and probably depending on when we get done today, won't get back until 5 or 6, so that would be 26 hours, but I'll cap it at 12 hours just for accounting purposes. But in this case, I agreed to a flat fee. So what I did in calculating the $150 an hour, which is roughly what I was making when I worked for the state, counting benefits, et cetera, I counted the 40 hours of work plus 12 hours for the day, included in that 40.
And you bill for these things now because this is your primary source of income?
That's my job. I've worked 31 years. I worked for the government for 27 years, and fortunately was able to grow a consulting company since '91, and got to the point a couple of years ago where I said, you know, I think I can do this.
I think the way you phrased it yesterday, you said you worked for the man for 30 years, and now you work for yourself?
I worked for the man for maybe 26, 27 years.
The man, the government, doesn't pay as well as working forensics for yourself?
No, sir. Actually, as I said, you look at my overhead expenses, vacation, medical care, insurance, it's pretty much a wash. Actually, when I worked for the state of Alabama, our retired employees, when they left, they were contracted at $150 an hour. So they ended up in a better place than I am, to be honest with you.
When did you become aware that there was press coverage on this case?
I believe Mr. Hendrickson told me that maybe a week ago. It was after the 25th, I'm sure. But I think he said Court TV wants to cover it or something like that. And my response was, okay, with the media in the courtroom, every trial I have. I testified earlier in Savannah this week for a case I did for GBI, and there was media in that courtroom.
Did you watch any of the media coverage this week?
No, sir.
Okay. Last night, did you go back and watch anything?
No, sir. To be honest with you, there's no media coverage of this trial that I'm aware of in Savannah, and I really don't follow my cases in the media. I don't really care.
You don't really care about your media coverage?
No, sir, I don't care about media coverage. I'm here to look at a case and try to figure out what happened. Other people are interested in it, that's great. But I do this enough that I don't want to have my whole life saturated in this.
Dr. Downs, if we went to your website and pulled up the About You section for your business, don't you cite in reference to news and television appearances?
Yes, sir, there's several links to different testimonies that I've given, different cases that I've done. People are interested in that, like I said, but I personally am not.
It helps your business, though, doesn't it?
I really couldn't tell you, sir. Nobody has ever said, oh, I saw this video on your website, so I decided to come to you. That's typically not what happens. Typically what happens is an attorney hears about me from another attorney and says, you might call Dr. Downs.
Let's go back to your report, a few things.
Sure.
So let's talk about page 43.
Yes, sir.
You give a list of the materials that you reviewed, is that correct?
That's correct.
Okay. And so if I follow along with me, you reviewed the autopsy report.
Yes, sir.
You reviewed some of the reports, I guess, related to that autopsy report, the blood examination, pillow, things like that.
That's correct.
You looked at the video interview and demo by the defendant.
Correct.
Now, you did not review his other two statements, right?
I did. Those were the ones we referred to earlier that I listened to last night.
But you didn't listen to those when you created your report.
I was not provided those until I found out that they existed yesterday and asked that I get them, which I then stopped what I was doing to listen to those in anticipation of today.
You listened to the voicemails from Mr. Bennett to his daughter.
Correct.
Okay. I want to talk about that for a minute. Do you know when those voicemails were made?
There wasn't a timestamp in the electronic files have what's called metadata that'll tell you.
Sir, and I know you could talk about that.
Judge,
I'm going to let him answer, but I'm going to ask, can you answer my question first? before you start going into all the other stuff. Were you aware of the time that those voicemails were made?
I am.
Yes or no?
I am now. So yes, I am now.
Okay. Were you before you did your report?
No, sir, I was not specifically. I had a general sense of the time that was relayed to me by Mr. Hendrickson.
Okay. Did you review a photo of an
Judge, I'm going
phone?
to object. He was supposed to allow the witness to, the witness was interrupted talking about metadata, and he didn't get a chance to
He can
that.
finish his answer.
So metadata is electronic information that's in a digital file that tells you when it was created. So I can go back in a picture file, for example, and tell you what kind of camera took this, what the settings were on the camera.
All right, more of this testy exchange between the prosecution and the defense's first witness, Dr. James Downs, when we come back. So stay tuned to Court TV.
Was no metadata.
Welcome back to Court TV. More from Dr. James Downs on the stand under cross-examination. Let's get you back inside.
Agree with Dr. Gulledge's documentation.
If Dr. Gulledge didn't document it, then there was no injury. You agree with that?
I would agree that he documented what he saw, and that's what is there. There are injuries that were noted in the medical record or findings in the medical record that weren't confirmed at autopsy.
I'm going to show you a picture, which is State's Exhibit 32. I'm going to put it on the scene, on the screen first, and then I've got to find it here. Are you familiar with keratosis?
Yes, sir.
Okay. Is there keratosis on Mr. Bennett's forehead?
It appears to me to be a scab. I could not be more specific than that from this photograph.
Dr. Gulledge did not note a scab on the forehead of Mr. Bennett in his report, correct?
I'd have to go back and look at his report specifically.
So you didn't talk to Dr. Gulledge about keratosis on his forehead and how that's not an injury?
I did not talk to Dr. Gulledge. I typically wouldn't talk to somebody. I would get the information from the report and from the visuals of what I see. If he was of the opinion that was a keratosis, then certainly it should have been documented in his autopsy report.
Yeah, you referenced on direct injuries to, I guess, scabs on the knee and then the forehead. Is that what you're referring to?
Yes, sir.
Okay. Even if that's not keratosis, you agree that did not occur on August 15th of 2017?
Well, it doesn't look anything like a keratosis at all. But no,